After heated exchange, Matthew Whitaker says he will testify Friday before the House, the New York by end. Washington U. After a heated back and forth, the chairman of the House Judiciary Committee, Gerald Nadler, bowed to the wishes of the acting Attorney General, Matthew G. Whitaker, that he not issue a subpoena while Mr. Whitaker testifies before the committee as scheduled on Friday. Earlier in the day, the Justice Department sent the committee demanding a commitment in writing that any subpoena not be used during the hearing, a promise that Mr. Nadler, Democrat of New York, follow are. But after negotiations that began early in the evening, the committee agreed verbally and in writing not to issue a subpoena on or before February 8, according to a Justice Department spokeswoman, Carrie Kupik. In light of that commitment, Acting Attorney General Whitaker looks forward to voluntarily appearing at tomorrow's hearing and discussing the great work of the Department of Justice, Ms. Kupik said. Mr. Nadler originally told Mr. Whitaker that there would be no need for the subpoena if he came prepared to answer questions, and that the committee was willing to work with him on a case-by-case basis on any question he felt he could not answer. He then said on Twitter that Mr. Whitaker would be joining the committee. But Mr. Nadler did not mention that he also gave Mr. Whitaker the written assurance that he sought. Representative Doug, once given the verbal and written promise, the Justice Department told the committee that Mr. Whitaker would be at the hearing on Friday. The latest turn in the political drama started on Thursday morning, when the committee voted to give its chairman, Mr. Nadler, the authority to subpoena Mr. Whitaker if he did not answer questions during the hearing or if he chose not to show up. Democrats want to ask Mr. Whitaker about matters related to the Russia investigation led by the special counsel, Robert S. Mueller III, and whether Mr. Trump replaced Attorney General Jeff Sessions with Mr. Whitaker to interfere with that inquiry. Some Democrat, I hope not to have to use the subpoena, Mr. Nadler said on Thursday. Unfortunately, while Mr. Whitaker had agreed to testify voluntarily, the potential that Mr. Nadler could subpoena him in the middle of the hearing was essentially a threat to initiate contempt of Congress proceedings if Mr. Whitaker refused to answer questions without a legal right to balk. On Thursday afternoon, the Justice Department demanded that Mr. Nadler not use that power during the hearing. We seek a written assurance from your office that the committee will not issue a subpoena to the acting Attorney General on or before February 8, the department wrote, and that the committee will engage in good faith negotiations with the department before issuing such a subpoena. The letter raised the possibility that Mr. Whitaker might not testify before William P. Barr is confirmed as the next Attorney General. The Senate Judiciary. During the first 2 years of the Trump administration, when Democrats were in the minority, they bristled when refused to answer their questions about communications with the president on the grounds that Mr. Trump might, in the future, want to invoke executive privilege over them, even though Mr. Trump never actually did so. Executive privilege is a power that presidents have claimed under the Constitution to prevent Congress from gaining access to internal executive branch information, like confidential communications between the president and his advisors. But such information, with Democrats now in control of the House, Mr. Nadler is trying to avoid such stonewalling. On January 22, outlining questions that Democrats might ask him about his conversations with Mr. Trump and asked him to consult the White House ahead of time about whether Mr. Trump would invoke the privilege over them. Absent such if a witness refuses to answer a question during a congressional hearing without a legal right to do so, the House can vote to hold him in contempt. Congress can then. In 2012, Eric H. Holder Jr. was the first Attorney General to be held in contempt of Congress for refusing to comply with a subpoena for information. But the Justice Department has long considered a subpoena to be a necessary precursor to Congress holding an executive branch official in contempt. Its letter to Mr. We cannot understand this measure other than as an attempt to circumvent the constitutionally required accommodation process and thereby to transform the hearing into a public spectacle, the department's letter said. The letter also noted that previous executive branch officials of both parties have declined to answer questions that might be subject to executive privilege, and cited instructing officials asked by lawmakers about information that might be subject to the privilege to hold the request pending a final determination. Still, those at the committee meeting earlier on Thursday, the approval to give Mr. Nadler the authority to issue the subpoena fell along party lines. Mr. Collins of Georgia called the subpoena political theater. In a statement, the committee now has deviated from historic practice and protocol and taken the unnecessary and premature step of authorizing a subpoena to me, Mr. Whitaker said, adding, "Political theater is not the purpose of an oversight hearing, and I will not allow that to be the case." While Mr. Nadler said that the committee would conduct the hearing in good faith, he did not withdraw the subpoena, leaving open the possibility of using it at a future date.
Raindrop, drop top smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up, open the park pot.